right, we will go on the record in the matter 23.
Welcome back. And just like that, we're in session. Divorce court drama is on the docket, with property disputes taking center stage. And yes, things are about to get messy. Stick around, because by the end of this hearing, you'll see just how complicated a simple shed can become in the eyes of the law.
A35, in re the marriage of Anita Gregelko versus William Daniels. We're set today in this matter for two reasons. One is on order to show cause contempt, as well as another for a request for petition from
the infamous shed. To most, it's just wood and nails, but legally, it could mean thousands of dollars or even someone's future living space. Who would have thought a simple storage unit could ignite this much courtroom heat?
Mr. Daniels, as it relates to the property and his personal property, and I believe the shed that is on the former marital home. So I have both of these in front of me. The order to show cause was filed after, and we have Mr. Daniels' motion that was filed first. So Mr. Daniels, you're going to proceed first, and you have the burden on your matter. Ms. Gregelko, you have the burden on your matter. I'm going to have both of you please stand.
3 classic moments, both times. But let me ask you, if you were about to swear in front of a judge, could you honestly keep a straight face, or would the nerves get the better of you?
Stand up, raise your right hand, be sworn in.
Do you affirm that the testimony you're about to provide in this matter should be the truth, the whole truth, and nothing but the truth?
I do.
All right, do you have any witnesses, either of you?
Nope.
No? It's just both of you? Oh. All right, so Mr. Daniels, you may begin as it relates to your matter.
My matter's pretty simple. Since I was removed from the household, I was never allowed to go back and get
Please
anything.
put the microphone a little bit closer to you.
There you go. Better. Since I was removed from the house, I was never allowed to go back and get anything, clothes, anything of that nature. And that's why I put the motion in to go retrieve some of my property. And it's been, I don't know how long now.
You win?
Well, I just like the chance to go get it.
A, no idea what you're talking about. B, you have to prove to me that you've attempted to try and...
I've contacted the sheriff's office because I heard they escort you there. But then they wouldn't do it. They said it's now a civil matter. You got to take it in front of the court. So here I am.
Quick breakdown, this part important. The sheriff won't step in because once property division turns into a civil matter, it's no longer their job. Translation, only the court has the power to decide who gets what after a divorce.
Okay.
I
don't know if you have any property. I don't know what you're asking for. I know nothing. I'm going to go now to the marital settlement agreement that was kind of crappily done.
Yeah.
You know that because you did it. So I'm going to bring that up because that is the law of the land. It was entered into a court order because you both came and said, we're going to do it. We're going to do it. And the commissioner told you twice, bad idea, bad idea. But then you wanted to plow through because you thought you can do it.
Dramatic highlight. Boom, there it is. The judge flat out reminding them that their DIY divorce settlement might have been a huge mistake. Pro tip. When a commissioner warns you, bad idea, it's usually smart to listen the first time.
So I'm going to look at that because that'll tell me what you are legally entitled to. And then we'll go from there. But I can't just say, okay, you can get your stuff because you're not telling me what stuff you have. So I'm seeing right here from the marital settlement agreement, full agreement, signed by the court, property at all, other than the poorly done real estate agreement. So that was not addressed. And you know, your underwear at the time of divorce is half hers. Her underwear, half yours. It's all great, but that's the law.
Did you catch that? The judge basically joked that even underwear could be divided 50-50. Divorce court really doesn't spare a thing. Makes you wonder, what's the strangest item you've ever seen people fight over?
Unless there's an agreement that specifically says, okay, Mr. Daniels gets the pots, the pans, the table. I have nothing.
That's fine.
So I can't just go, okay, you want your property, you get it, because I don't even know what you're asking for.
But that's fine.
You want nothing.
Nope, don't need nothing. It's all.
Then why are we here?
Well, I didn't even have a chance to get a change of clothes when I left. Everything was left there.
So even though the law says, and I know Commissioner went over it with you because he's very thorough, the law says after the date of divorce, what's in your hands is in your hands, what's in your hands is in her, or in her hands is in her hands, unless there's some type of order, which would be inclusive, it would include that marital settlement agreement that says that there's this type of division. We're here, you can just kind of see. Otherwise, why are we wasting the court's time? So if you want stuff, you got to ask me right now so I can talk to her
put in
and see.
Documents for the shed.
Yeah, I have a letter. That's
Yeah.
correct. You're asking for a shed. Okay. What else? I don't even know after the divorce, because we're talking about something that was done December 2023. We're going on 2 years.
Yeah, and I haven't been allowed in there since.
Yep, because it's not yours. And so here's
It's
the
not
thing,
mine, but-
2 years. And so I don't know if there's even a change of clothing of yours in the house.
Probably not anymore.
Ms. Craig Ilko, is there any personal property of Mr. Daniels in that home?
Yes.
Okay, I'm going to get more from you than I'm getting from him. What is in that?
And here it is. Anita speaks up. Notice how the judge leans more on her testimony than his. In court, the side with clear details and solid evidence almost always carries more weight than vague claims.
Home that you would be prepared to say, you know what, take it all. You sure can, but you have to get them marked, please. And then show them to Mr. Daniels.
Bring them to me and I'll mark them.
Are they all of the property that you're saying is his? You can have them all marked and they can all be marked as one exhibit.
This is the shed that I want left on the property, because it's got electric.
Okay, I don't, whatever you're saying is not going on the record. So I don't know if you're just talking to her
Okay.
about marking stuff.
That's marking stuff.
I said to mark them all as one exhibit,
Oh,
so all of it can go together. Nope, same thing. She said all the photographs go together.
This makes it easier. All right, so first show it to Mr. Daniels.
This is the shed that has the electricity into it.
You don't have to explain to it. Just give them to him, let him see them.
Set your tape, and here's your couch and stuff.
All right, you don't, again, don't have to talk to him. Show him, put them back up in your hands, and then bring them to me. All he needs to do is see them. Thank you. Now, what are you trying to have me see with these pictures?
The couch Nobody said.
Don't care who sits on it. I don't care who doesn't. If you're saying it's his, boom.
Yeah. The entertainment system.
Again, I don't need the commentary.
And then.
Okay. Unless you're arguing and you're saying, I believe I deserve the shed is mine, I don't care that there's electricity.
Okay.
So,
I believe.
all right, so what else is his in the home? Nothing else that you can think of in the shed that I have here?
Yep. Clothes. Clothes. Otherwise, he has.
And so he has a TV?
Yep.
Any dishes? Okay, how long would it take you to go through your house and take all kinds of boxes and pack it all up nicely, not damaging anything? How long will it take you to go through the entire house and say, this looks like it was Mr. Daniels, and throw it in?
A single day to box up years of marriage. Just think about that. All those memories, all those shared possessions, reduced cardboard boxes in a matter of hours. Brutal, yes, but that's divorce.
Only a half a day?
Yeah, there's nothing.
All right. Okay. Now, Mr. Daniels, as it relates to the shed, she is contesting that that is your property. I do have your petition, your letter petition, so I have what you say in there, but that's not evidence. So now you tell me why you believe the shed is yours and why it should be ordered to you.
Well, I made all the payments on the shed. I put the electricity in. I'm the one who purchased it.
So that was after the divorce?
That was before the divorce.
Okay, so before the divorce, you're all happily married, even if you weren't. And all the money that you spend and all the money that she spends, all of the stuff goes to the property. And so it's called marital property.
We had an arrangement where certain bills were ours and certain bills were theirs.
Doesn't matter.
I know, but that's just what I'm saying.
Okay, so now tell me, as of the date of divorce and what the agreement was, the date of divorce, because I know, but you need to tell me on the record.
You know, we had spoken before where it was you could have the house and I would take the shed and build and live in that. That was the only conversation we had about the shed, to where I could have some place to stay.
Okay, well, to go to the marital settlement agreement. All right, well, there's nothing that said shed in particular as it relates to the marital settlement agreement or the shed when we came back in April of this year as it related to the.
Here's an important point. Once a marital settlement agreement is signed, it becomes the law of the land. If the shed or anything else wasn't clearly written into the deal, the court is bound by the words on paper, not by what anyone may have intended.
Kind of sorting through the terrible marital settlement. So the court at that time in April of 2025 ordered that the home can be refinanced and purchased by Ms. Greg Ilko. I don't believe that the shed was addressed. The shed, or what you're referring to as the shed in the marital settlement agreement, is called a bunker, or it was called a bunkhouse. You would build a bunkhouse down the hill. So I have bunkhouse down below the hill, and that's where you were going to reside if you two were still getting along. Obviously, you weren't getting along, and that's why we needed the April matter. And so now we're here. So explain to me, define bunkhouse.
Well, it's just a place where I could reside. Someplace either I could fix up or build.
I get a definition of what a bunkhouse is. Why are you telling me that the shed is the bunkhouse?
Well, I was planning on just starting with that. So since it's cheaper, it's already built and I can just add on.
Describe the shed to me.
It's just a 10 by 12 or 10 by 16. Forget what size it is. It's got upper level bunks or upper level loss on both ends. It's nothing spectacular. It's just a regular shed you buy like on the side of the street or.
So there's no walls on the inside other than the.
No, I would have to finish it all.
Okay. When was the shed purchased in contemplation of the bunkhouse?
I don't know the exact date. The dates were on the payments I had gave you prior.
When did you give me payments?
I sent, along with that note for the shed, I had a payment schedule sent in also. They had the dates, so I.
It's in tiny language, little font. Oh, I can't really read it when it's microscopic font. What looks like, see, you're making me testify for you. You're supposed to be prepared. You're supposed to have this stuff. You're supposed to have it in front of you. You're supposed to say, hey, judge, I may have given this to you, but I have it right here and I'm going to tell you, I'm going to testify and I'm going to give you this information because when I file it with my motion, it's not evident.
I made the mistake of giving you my only copy.
And then that gets thrown away because it gets scanned. So when did you purchase it? Around what year?
Best guess would be eight years ago.
So if I said, would you recall it being in or around May 2018? Would that sound correct?
Could.
That's the first date I'm seeing on this invoice. Now, 2018 was when you purchased this. The divorce didn't occur until 2023. So was it always the plan that you would not live in the house and you would live in a bunkhouse?
No,
And why was the shed purchased?
it was purchased just to store stuff in. Because she had an apartment she was living in St. Croix Falls that we had to put all our stuff in when she moved into my residence.
So when it was purchased, there was no intention for you to convert that to a bunkhouse.
Right.
Now, shoot me up to 2023 when you're getting divorced, and I'm not going to have you give me too much. We believed it was our intent, these kinds of things, but you put in marital settlement agreement that William will be building a bunkhouse down below the hill and will reside there sometime in the near future. So now it says that you're going to build a bunkhouse. To me, that doesn't mean that there is an intention to have the shed be the bunkhouse.
It was only an option to add on to that as a building.
Why wasn't that put into your marital settlement agreement?
Because I didn't write it that way.
It wasn't written anyway with a shed. It said we'll be building a
Right.
bunkhouse. Doesn't say we'll be adding on to the shed and creating a bunkhouse.
Yeah, when you write it, you don't think of that smaller details all the time.
But the commissioner told you.
Yeah.
I know he did twice. He didn't want to go through with it and go and have this marital settlement agreement be approved. But you said to him, what did you say? Gonna be great. Please do it. Please, please, please.
Right.
So the next time you get divorced,
Ouch! That's a judge throwing shade, basically saying, don't DIY your divorce papers. So, viewers, what do you think? Is saving a little money up front really worth the risk of years of messy legal battles?
I strongly suggest you don't write your own marital settlement agreement. Either get a lawyer or you hash it out in a court, because otherwise we're here and I have to decipher what it means. But when I look at a contract, I'm told I have to look at exactly what the words mean and say. I can't interpret and go, they meant shed, they meant they were going to add on to it. Because that's not what you're supposed to do when you are interpreting contractual language. And I'm going to tell you, I wasn't there at the hearing, but my gut tells me that the commissioner strongly tried to discourage this from continuing and having this be in order. Precisely for those reasons. So, all right. Ms. Gregelko, I have heard Mr. Daniels and his perspective on the shed and the bunkhouse. And I obviously did an order as it relates to the house in April of 2025. What's your position as it relates to this shed?
I helped to put.
Again, don't care about that.
Oh, and
Again, don't care about that. Because whether or not it stays in the refinancing determines what I do today. Get it, but he says he needs it and wants it too. So I don't care who needs it or wants it. Right now, I'm trying to determine, based upon your marital settlement agreement and where we are here today, whether or not this was supposed to be for Mr. Daniels and his ownership or the marital property. Again, that's not my issue. Okay. He could have paid 1,000% of it and it wouldn't have mattered because you were married. In the marital settlement agreement, and I'm going to read it again, it says, quote, William will be building a bunkhouse down below the hill and will reside there sometime in the near future or as soon as funds can be saved for said project, end quote. What do you mean you talked about it?
We talked about the shed.
What was talked about with the shed? But when you did this marital settlement agreement, prior to the commissioner granting the divorce, you contemplated the shed as the bunkhouse. All right. And that's when all things were hunky-dory in your divorce and you were all gonna get along and there'd be rainbows and butterflies.
The judge just nailed it. So many divorces begin with the best of intentions. We'll stay friends. It'll be peaceful. But fast forward to today, and they're battling over a shed. Real talk. It almost never stays pretty.
Okay. All right. I'm gonna guess that the bunkhouse or the shed is not located where the bunkhouse was gonna be, below the hill. But you are admitting that you contemplated the shed as being potential bunkhouse or use.
Yes, we talked.
Now, Mr. Daniels, as the marital settlement agreement and the divorce order does not contain any personal property or anything of that for the court to go along with, you heard the list of items that Ms. Gregelko admits are yours. I'm just gonna open it up a little bit to you. Other than those items that were listed, is there anything in particular that you can think of, such as a family heirloom or anything of importance or anything like that in the house that you would like to just ask for today?
The only things, without getting a detailed list of everything, so just bag list, would be the really personal items like she mentioned, pictures, stuff like that, and tools, set of golf clubs.
And do you have
And,
family photos there,
Yes,
like photo albums?
I don't have, oh, I just have pictures.
So some tools, golf clubs, other things that you can think of. I'm going to tell you, this is it.
Yeah, just whatever she deems mine is fine with me. I really don't want anything other than the couple items I listed.
Okay, all right.
And there it is. He's basically waving the white flag, asking only for a few personal items. But the bigger battle, the shed, still hangs in the balance. Stick around, because that decision could change everything.
All right, so now I've heard Mr. Daniels' motion. Now I'm going to listen to your motion. You have a order to show cause and you're asking for contempt. Will not sign title, so cannot finalize closing. You have the deed with you.
No.
Divorce is done.
I know.
So, okay, what I didn't quite understand though is you sent a letter yesterday. Mr. Daniels, did you get a copy of that letter?
No, I tried.
All right, I'm gonna print it for you. I'm not saying that I'm even taking it into consideration since it was filed yesterday. And again, it has the microscopic little language, the font. So you're probably not gonna get to read it because you need a magnifying glass. But I'm gonna print it out for you and you can attempt to read it just like I attempted to read it.